Ladies and gentlemen, welcome back to the Indiezone. My name is Kathy. We have some breaking news for you out of the United States District Court, Western District of Washington. This is the Seattle Division. Matter styled as Steve Goncalves et al. Versus Washington State University. The document number is 23. It was filed in the case today, March 19th, 2026. It's on our community page of our YouTube channel. I've published a link to our community page so that you can read it for yourself in the description to this podcast episode. What is this? Joint notice to withdraw pending motions. Notes on motion calendar, March 19th, 2026. What does it say? The parties have conferred and reached a stipulation. That's an agreement, ladies and gentlemen. Pursuant to that stipulation, each party hereby withdraws one motion pending before this court. Pending before the court, ladies and gentlemen, means that it is a motion. A motion is an application for a court order. Pending means it has not yet been ruled upon. What are the two motions? Number one, the defendant withdraws its motion to transfer venue. This is document number 8. And plaintiffs withdraw their motion to strike the defendant's answer, document number 19. The parties have further stipulated that the withdrawal of these motions shall be with prejudice. What does this mean? With prejudice means they're not going to file it again. This is a done deal. There will be no future refilings of the motion to transfer venue or the motion to strike defendant's answer. Without prejudice means it would leave the door open to a possible refiling in the future of this motion to transfer venue and or the motion to strike defendant's answer. Again, the parties have further stipulated that the withdrawal of these motions shall be with prejudice. Defendant will not seek transfer to an alternative venue, and plaintiffs will not seek to strike defendant's answer. Defendant further reserves the right to file an amended answer, and plaintiffs consent to such filing pursuant to FRCP 15A2, that is Federal Rule Civil Procedure 15A2, that gives a party the right to file an amended pleading under certain conditions. For example, it would have to be done before the forthcoming deadline in the scheduling order that we are now looking for. Continuing on, the parties note that one of the motions, the motion to transfer venue, is past the noting date of February 27th, 2016. That looks like a typographical error. They obviously intended to write February 27th, 2026. And the parties will contact the court. Why is this? Well, as they've said here, the motion to transfer venue is past the noting date of February 27th. That was the date that the matter was ripe for the court's consideration. That's why we kept looking to see if there was going to be a hearing, as the plaintiffs asked, on the motion to transfer venue, or if there was an order that was on the docket on that motion to transfer venue, because all of the briefings were in. The motion, response, reply. The matter was ready for a ruling. The other matter, the motion to strike the defendant's answer, noting date for that is not until tomorrow. And so that motion is not yet ripe for the court's consideration. They're going to contact the court to let the court know, just in case, to avoid the filing of a court order on that motion to transfer venue. Next page. Signed this 19th day of March 2026, respectfully submitted. And we see here on behalf of the plaintiff's attorney, Thomas B. Vertatis, and Jonathan P. Kleifer. And then attorneys for the defense, this is submitted by Jordan Jones. She is an assistant attorney general. She's one of 3 that are on this case. Okay, what does this mean? Number 1, case isn't going anywhere. It's staying in the Western District of Washington. It will be before this judge. And then, as we have mentioned, now finally the scheduling order is going to come out that will assign all of the relevant dates and times, matters that must happen. Mediation must happen by a certain date. Motions to amend. Remember, under the first affirmative defense, what did WSU say? That there might be other parties or entities that the plaintiffs might look to for any damages. Maybe we'll see some third-party practice coming in here with a counter plaintiff. That would be Washington State University, and a counter defendant, possibly. Again, complete speculation here. Other dates and items that you look forward to seeing on the scheduling order: discovery cutoff, when all of the depositions, for example, must happen by. A cutoff date that all requests for production of documents and things, requests for admissions, interrogatories, all of the discovery tools that parties use to either prove their claims, if you're the plaintiffs, or prove their defenses if you are Washington State University. And finally, for the public, this means there is a possibility that some hearings, maybe even trial, could be broadcast, because remember what we have been saying all along. The Western District of Washington is part of a pilot program in the federal court system that allows for the potential for broadcast live of certain proceedings. There's a process. One of the parties would have to apply for it. A member of the public, the media, could apply for it. That potential did not exist in the Eastern District. If this case would have been transferred, the Eastern District is not part of that pilot program. Federal courts usually do not televise live their proceedings, but there are certain courts across the country that are part of this pilot program, and the Western District of Washington is one of the 3 in the 9th Circuit Court of Appeal geographical area that is. We will continue to keep you posted as further developments arise. Until next time, this is Kathy. Thank you for joining us here today.